Good evening, everyone. First of all, my apologies for inability to have started at the time that I had wanted to start with you. I have to be away from the jurisdiction, and that affected also my availability. That notwithstanding, since I have always enjoyed being with students, I have decided to do whatever I can, whatever time that I'm able to afford, to have some interaction with you. Hopefully, you are assisted or you are supported in one way or the other to be able to hold yourself in readiness for the crucial entrance examination that you are preparing towards. Yeah, so that's my apology, sincerely rendered. Having said that, there's a few housekeeping rules. The first rule is that I'm going to release the mic, but I do not expect that you will leave your mic on for the background noise at your end to come in. You only release your mic where you have been permitted, to speak, as in maybe you asking a question or making a contribution. That way, we are able to manage the noise that may come in from the background unintended and would actually distort what we are seeking to do. So once we have agreed on that, I am going to put on release the mic, but make sure your mic is off unless you are permitted to speak. That way we have an order in the virtual class. Thank you very much for understanding. Yeah, so having said that, the purpose of tonight's meeting is just to, first of all, touch base and also have a bit of like a pep talk with you as far as the new arrangements that the IEC has put together with respect to 2024 and future entrance examination. And then in our subsequent class, we pick some substantive areas and then we engage. So first of all, I understand, and I'm sure everyone here is aware that the entrance examination towards the Ghana School of Law admission this year is going to be organized in a significant way, different from how it has been in terms of structure. Because as you read from the publication they did, now all the 6 examinable subjects are on the table because the new rule which they have brought is that you are going to answer 6 questions. So if you are supposed to be studying towards 6 subjects and you are told that you are going to be given 6 questions, then one would like to assume that, and reasonably so, that there will be a question from each of the 6 subjects. And you are required to answer 4 of that. I think that is what the instruction says, unless I read it differently, in which case I'll be very happy to be corrected by anyone who knows it better than I do. Thank you. Otherwise, the understanding is that 6 questions, answer 4. And as I said, the examinable subjects already 6. So it is logical to infer that there could be a question from each of the 6 areas. But the good news is that you are not required to answer all the 6. You are required to answer 4 out of the 6 questions. Now, if that is the case, I think that it's a sigh of relief for students who are going to do the exams this year and beyond. And I think that you should relax and you shouldn't be afraid at all, because unlike the old regime, which was said that you are given 2 questions, answer all. And the 2 questions will come from 2 subject areas which you do not know. So it may well be that you are studying constitutional law and contract very well. And let's say that in the past, the question will probably come from just contract and let's say land law. Should it happen that way, depending upon the scope and the depth of the revision that you did, you could encounter some rare challenge regarding your preparedness to be able to answer the question in a way which will enable you to score highest marks as possible. Mind you, this is a highly competitive examination in the sense that much as they will say that they are prepared to take everyone, the fact of the matter remains that the resources and the logistics available are just not enough for all the 3,000 or nearly 3,000 students who will write the examination. And for that matter, some will definitely have to be delayed, maybe until future time. And you don't want to be one of those who will delay. So how do you write what is needed to be written in the old regime? There's 2 questions. And that is why I'm saying that the new regime of 6 question answer 4 is better. Now, under the current dispensation, 6 questions answer 4. What is the best strategy to employ as a student? Now, if you look at it effectively, we have just about, today is 16th August, and I think you are writing the exam the first week of September. So practically about 3 weeks or so to go. So how do you proceed? Well, I will propose to you some few strategies. To start with, I want to believe that you have been learning all the subjects since the beginning of the year or whenever you started. I am sure that you have heeded the advice I gave in my earlier videos, especially one video I call, I think, the practical strategies for effective preparation or something like that. And it's one of it's available on the Ghana Law TV YouTube channel, in which I gave some concrete steps regarding how you prepare effectively for this examination. So I'm sure that has been done. So assuming you have already done that, so question is, how do you position yourself so that you are able to get very good 4 answers, or you get your 4 questions, you can write very good answers. Assuming we don't know how they're going to do the mass allocation, by going by our simple experience as teachers, one could argue that if students are going to answer 4 questions out of 6, it is likely that each question will attract 25 marks, in which case the 4 questions will be 100 marks. So 25, 25, 25 will give you like 100. So that could, one particular way of going about it. Or worst case scenario, to say that each question is 50 marks. in which case you get 200. But I would like to believe that the former, that is the 25-25, is the more traditional way and is likely to be that. So you are going to answer 4 questions, 25 each question. How do you write answers, which will enable you, if you are not doing well at all, if you are not doing well at all, to get 15 marks out of 25 for each question. So to play safe, and maybe as a modest and student, yes, 25 is what you should go for. But should it happen that you are not doing well at all, your average performance should be, let's say, 15 over what? 25, in which case the 4 questions will give you 60 marks and 60 marks. And if you get 15 over 25, that is more than half of that. And that should put you on the trajectory of actually cruising to victory, or being part of those who will be selected to go to the law school. Now, that is easier said than done. So how do you actually make use of the 3 ways or so which you have on hand before you write the exams? Somebody who has a question. Must I study all the 6 subjects? When, in any case, I'm going to write only, I'm going to answer only 4. Or must I concentrate on 4 subjects and leave 2 subjects? Now, if I concentrate on 4 subjects, and should it happen that the questions which will come in the 6 examinable areas are, let's say that, yes, the 4 questions, the 4 subjects I study, yes, there are questions there, but honestly, I can answer only 2 questions very well, the other 2 not too well. But there are the other 2 questions in the 2 other subject areas, which I didn't really take serious because I had decided not to answer questions from there. Now, if it should happen that way, how do I navigate so as to be able to come out successfully? And that is why I want to have this pep talk with you and give you maybe some a few strategies or tips. Well, as your senior brother or teacher, my suggestion would be that if you look at the 6 subjects, right? Constitutional law, law of contract, land law, movable property, criminal law, law of tort, Ghana legal system, and legal method. I will propose that whatever choice you are going to make, constitutional law and Ghana legal system should be part of it, okay? Constitutional law in the sense that constitutional law, goes beyond constitutional law and also transcends to some other subject areas. You can have a question from, let's say, torts, which may have a constitutional law twist, just as like previously, they had to discuss unlawful arrests, forced imprisonment and things like that, and not only that. So here, you see that you are doing a question in tort, but there is some aspect of constitutional law from it. Or you have a question from land law, there may be a constitutional law dimension. And the same thing also applies to criminal law. For example, you've seen the previous question, I think the principles of a fair trial or something like that, essentially a discussion of Article 20 and some others. So if you look at it from that perspective, constitutional law should not be left out in the 4 subjects that you are going to target within the next 21 days, which you have before you. And if you need to include constitutional law, the topics in constitutional law are many. So ask yourself, first and foremost, there are some basic, or what we call foundational principles of constitutional law in Ghana. Do I know them? If I don't know them, I have opportunity to quickly brush up. And what are these foundational principles? So first, we have said that you have to know the foundational theoretical concepts. When we say constitutionalism, basically, what does it mean? Separation of powers, basically, what does it mean? And how is it reflected in the Constitution, right? Rule of law, what does it mean? And how do you relate it to the Constitution of Ghana? Judicial review, what does it mean? How do you relate it to the Constitution of Ghana? Judicial independence, checks and balances, what do these things mean? How do they relate to the Constitution of Ghana? So these are the basic things you have to know in terms of constitutional theory, right? And it's not difficult. You can, if you've even forgotten, we can quickly brush it up. So that is 1. And 2, you come to certain elementary pillars of the constitutional law of Ghana itself. At this stage, all of us should understand principles like the supremacy of the Constitution and also the enforcement. We need to understand that, and this has been tested over and over again. And in view of the fact that there has been a coup d'etat going on in, let's say, West African sub-region, and also the other treason case, which was tried, no one knows whether there will be interest in, for example, asking students to explore the effects of, let's say, a coup d'etat or revolution on the constitutional order. So if you look at the defense of the Constitution, if you look at Article 3 and so of the Constitution, when it comes to the defense of the Constitution, and also if you look at the jurisprudence, which has evolved around the effect of a coup d'etat, Salah versus the Attorney General, Expert Matovo, the Lakami cases, EPPM Michelle, and things like that. Yeah, so these are basic things, you get to understand them. And then when you are done with that, you take the executive arm of government, right? Read the provisions of the Constitution as relates to the executive. That should be your basic. If you don't know anything at all, that should be your basic. And as you do that, there are 1 or 2 key cases on the executive, which has been decided by the Supreme Court. So just get a few, like the major ones, not plenty, because most of them actually repeat the same principles as well. You do the same thing for the legislature, you do the same thing for the judiciary, and so on. And let me sound this note of caution. In the past, when they used to set only 2 questions, answer all, there was that tendency, or there was that temptation for students to think that the question would actually come from please.
Anyway,
Can you put off your mic if you've not been invited to speak? Yeah. So there was that temptation for students to think that the question will come from what you call topical issues or issues of currency. That is, issues which are being talked about. And for that matter, students will just concentrate on that and leave out aspects of the subject which are not topical, as not maybe issues have not come up in recent times or in the particular year for people to talk about. So they think that, oh, this is not an area the examiner may want to bring a question. Now, that is a mistake under the current arrangement. From what I've observed, right, from the how things are, I do not want to encourage you just to limit yourself to, let's say that the current issues, yes, they're talking about, should we cap the Supreme Court? They're talking about LGBTI. They're talking about this. So all your energies and attention are going to be limited to those current issues. If you do that, it is a big mistake, because from the new regime, one can surmise that it is not necessarily the case that the questions are just going to reflect current issues. Rather, the questions will come from anywhere in the syllabus as far as those subjects are concerned. So those are the things that I want to remind you of. Of course, you must also be familiar with the human rights chapter in the Directive Principles of State Policy as far as constitutional law is concerned, and so on. Now, when you go about constitutional law that way, you notice that you take the fear out of you. And now you're still left with 5 subjects. And I suggested to you that you must include constitutional law and Ghana legal system. The advantage of letting Ghana legal system and constitutional law be part of your 4 favorite subjects, let me put it that way, your 4 favorite subjects that, let's say that you're, because as the days draw closer, you may need to focus your preparation so that you are able to actually make effective use of the time that you have. And that is why it may be necessary for you to zero in on certain subjects and probably place less emphasis on others. And that's why I am suggesting to you that should you find yourself in that situation, then please don't neglect constitutional law. Don't neglect Ghana legal system and legal method. Now, the advantage of including Ghana legal system and legal method, certainly not because I have written the new books in those 2 areas, no. But the advantage is that the issues which are discussed in Ghana legal system and legal method on one hand, and constitutional law on the other hand, are cross-cutting. No, cross-cutting issues. Cross-cutting in the sense that some of the topics which are done in Ghana legal system and legal method are also relevant in constitutional law, and vice versa. Some of the things in constitutional law are also relevant in Ghana legal system and legal method. And that is why I want you to take that. For example, Ghana legal system and legal method, at the basic, the barest minimum, you have to know your sources of law very well. And sources of law, I want to recommend my new book to you as well, treated over there, the volume 1. You need to know your court structure very well. Court structure is also treated very well, because these 2 are very important, okay? And of course, as you are learning court structure too, you add judicial precedent to it, and also the rules of the statutory interpretation. Those are in like the volume 2 and all that. So if you take these matters serious, I would like to believe that you'll be holding yourself in readiness to be able to answer questions on constitutional law and Ghana legal system and legal method. And of course, you come to contracts, right? Contracts and tort. A student may say that, okay, I want to concentrate on contracts. I mean, that is fine. That is your choice. There's nothing wrong. And contract is also an area which you shouldn't have difficulty in trying to revise. And I must say that contract is the subject that you should be able to put your hand on your chest and say that I can answer every question A to Z in contract, regardless of how they are presented. Whether the question will come as an essay question or to come as a problem question, I am ready to answer that question. And talking about problem question, I have shared with you on previous videos on the Ghana Law TV channel, how to answer problem-based question. And of course, if you look at the volume 2 of my Ghana Legacy and Legal Method, I also have like a chapter on how to use the IRAC or the IPAC to answer problem-based question. The same things that I'll be discussing, we just documented it for ease of reference. So that is important. So contract, for example, ask yourself, what is it in contract that you cannot answer? If you are asked to explain, for example, the fact that every contract is an agreement, but it's not every agreement which is a contract. You ask yourself, is this something that I understand? Can I answer that? If I'm invited to, for example, look at basic things like formation of contracts, the test of agreement, how do you make a determination as to whether agreement exists or agreement does not exist? At this stage, if I put the books aside, can I just speak to it? Can I write something sensible? Am I convinced that the court usually use the objective test in making a determination as to whether the parties have reached agreement or not, and all that? And in that case, am I able to draw the line between what constitutes a definite proposal, which you call like the offer, and what does not constitute that, which you call an invitation to treat, and all that? So these are things that you should ask yourself. And then when it comes to acceptance, right? Acceptance and offer general, especially the communication aspect, you have to remember that we are in an age where everyone is talking about digitization. So the Electronic Transactions Act is very important. If you have not heeded the relevance of the Electronic Transaction Act to how do you call the formation of a contract, it is something that you have to look at well. Okay, so the Electronic Transactions Act, when it comes to making what you call like the e-contract, and also communication of offer, communication of acceptance, and all that, these things are important, which you have to look at as it were. And not only that, consideration, very simple, but a lot of students still find it very difficult. And I don't know why they find it difficult. And I have always held the view that consideration should be understood against the historical development of enforceable contracts. And what do I mean by that? We have to remember that we have two main types or forms of contracts. What we call the specialty contract, also known as contract by deed or contract under seal, which simply means that the contract is supposed to be in writing, it's supposed to have the signature of the parties, the seal, and so on. And for that matter, when it comes to enforcement, the courts are prepared to enforce that contract just because it's in that form. And the court does not need evidence as to what the other party who is seeking to enforce it did to the other party against whom is seeking to enforce it before it will enforce it. It is enough that such a contract with all those solemnities, writing, signature, and seal are there, and then the court to enforce it. And in that case, the position of the law is that it is not likely that someone is trying to tell a lie that there's a contract between him and the other when in fact there's no such contract. Otherwise, the person's seal will not have been on it. And that is the reason why historically we say that a contract under seal or contract by deed is enforceable without the necessity of providing consideration, as it were. On the other hand, we've talked about simple contract, also known as a paro contract. That contract is not required to be in writing whatsoever. And even if it is in writing, it is not required that the parties will put their seal. So the seal was like your special mark of authentication, that if that mark of yours is put on a document, you are telling the whole world that, yes, you mean what the document is saying, that the document is authentic from your point of view, as it were. Now, simple contract or paro contract does not have to have any of that. So it can even be by just word of mouth, just by word of mouth, or even like the conduct, as it were. And there may be a dispute as to whether such a contract has actually been made. There could be a dispute because it is your word against my word, so to speak, paro sometimes. So how will the court be able to tell whether genuinely such a contract was made or it was not made? And that is what brought about the requirement of consideration, as we call the element of exchange. Now, you are alleging, or you are certain that I promise to deliver a car to you, right, on a certain date, and I have not delivered it. So the court should hold that I'm breach of a promise or I'm breach of a contract. Now, apart from what you are asserting or alleging, there is no reliable evidence to let the court be convinced that there was such a promise or such an agreement. So the court will need to find out, what can you show that you did in return for the promise which I had made to deliver the car to you? Now, if I am able to show something I did in return, then it will remove the doubt as whether I am lying or I am just faking a promise on you, as it were. And that thing which I am showing as having done in return for the promise that I made to you is what is called consideration. Simple as that. So that is all. So we must understand this, and we have to know, how the common law doctrine developed. For example, things which will be accepted as consideration, as good consideration, that is sufficient consideration, and things will not be accepted as a good or sufficient consideration as common law. We have to know. And more importantly, we come to appreciate that all those common law ideas were interesting, but the most important thing is that from 1960 onwards, up to date, here in Ghana, we have made major departure from the common law. And we have stated that consideration is modified in no significant way, apart from one or two instances. Then you tell us about those changes under the Contract Act, as it were, and then you are done with consideration. So once you know these things, you should be able to answer any question on consideration. Then you look at the promissory estoppel dimension. When it comes to modification of contract, if there's a contract between you and me, and you want to say that I did something after the making of the contract, which shows that I have changed or modified the original obligation under the contract. Now, if you want the court to believe that the original terms have been changed, what do you need to show? And that is what brought about this idea of promissory estoppel and so on. The Height risk case, every law student knows it. Its various application, this modification and all that. You look at the Evidence Act of Ghana, section 26, the estoppel by conduct, estoppel by statement, and so on. So if you know this, then you should also know privity of contract. Privity of contract, very straightforward. The fact that originally, if you're not a party to your contract, you cannot enforce a contract and the contract cannot create an obligation for you. That was the original position. So you know that, and then you know the various, the basic cases which establish that. And if you don't remember anything at all, Dunlop against Selfridge will come handy, as it were. Then you make the point that that position was not cast in stone, because in view of the obvious injustices associated with it, even at common law and equity, a number of mechanisms or a number of exceptions evolve, so that a party who was not a part of the contract will still be able to enforce the contract either through equitable arrangement like trust, assignment, and so on and so forth. And of course, you come to the fact that in Ghana, we have statutorily modified the privity of contracts. And if a benefit is created for you, or you're part of a class for which a benefit has been created under a contract, you can enforce the contract and so on and so forth. So these are matters which are not difficult. I'm just using a broad brush approach, just to sketch these areas. So you ask yourself, at this stage, can I honestly say that I can answer every question on contract? When it comes to terms of contract, can I answer every question on terms of contract? When it comes to what do you call the vitiating factors, mistake, misrepresentation, duress, undue influence, can I answer every question on it? Illegality and public policy, can I answer every question on it? Discharge of contract and remedies for breach of contract, can I answer every question on it? And I want to propose to you that contract is one of the manageable subjects that it will not be out of place if you wanted to include it in the 4 subjects that you'll be targeting, so to speak. Of course, if they're going to bring this question, there's no way that they will not bring a question on contract. I'll be surprised if there was no question on contract. And for that matter, if you know all the topics in contract, then you have already secured one good question, which you'll be able to answer. So the next thing is whether the question going to come from there, will it be an essay question or to be a problem-based question? But once you know your stuff and you know how to go about the problem-based question, you also know how to go about the essay question, then you are not worried whether it's going to come as a problem or it's going to come as an essay. You're very much ready to do that. So I think that these are some of the the strategies that you can go about. Then you are left to tort, land law, and then what is the 6th one? What's the 6th one?
Criminal law.
Criminal law, good. Then you ask yourself, okay, so criminal law, land law, and tort. These 3, you need to take one more to add to the other 3 you've selected. Of course, let me say that the other two which will be left, it doesn't mean that you are going to ignore it completely. But maybe that is not like your main target, but you still have some some general revision of those other two, just as a backup in the sense that should it happen that the four that you targeted, maybe later on you have a change of mind regarding one of them and you want to look outside it, you still have something to fall on, okay? So when it comes to criminal law, you have to know what you call like the general part of criminal law, the basic theoretical part of criminal law. It's a must. Know what is a crime, what constitutes criminal liability. Actus reus, mens rea, you have to understand each of them. You have to know their dynamics. You have to understand the principle of strict liability. Those type of offenses in which you don't need the coincidence of actus reus and what, and mens rea and all that. You have to know that and then know examples. Then you come to, how do you call like the defenses, right? General defenses to criminal liability. You have to know that total and then the partial defenses as it were. Then you come to what you call specific offenses, okay? Now, specific offenses, before you take the examples, what we call the accessorial liability and things like that, like conspiracy, abetment, conspiracy, abetment, and even like an attempt. These are things which are basic and which you have to know. And after that, the specific offenses, we have like a very common ones. Homicide. Homicide, criminal homicide, murder, manslaughter. These are, you can't learn criminal law and say that you leave these things out. Then when it comes to offenses involving fraud and then property, stealing, dishonestly receiving, falsification and forgery is an interesting area for academic examination. The difference between, let's say, like the falsification and what, and forgery like that. Or just as it's also interesting to know the difference between either stealing and fraudulent breach of what, of trust, as it were, or dishonestly receiving. So if you know this, as for the criminal offenses, the offenses are many, but if you know the general theoretical part and the defenses, as I said, and then when it comes to like the specific offenses, you know these common major areas. These are the areas which are usually examinable. These are the areas which are usually examinable. Maybe, yes, there could be question on, let's say, that the anti-money laundering or something like that, but these are not common examinable areas because these are emerging crimes, and scholarship and jurisprudence has not even crystallized very well. So you wouldn't, for example, want to worry yourself so much about some of those obscure or not so traditional offenses, as it were. So if criminal law is what you're including, you go on that path and you include that. You come to, how do you call it, the tort. Tort, for example, has been an area of interest for quite some time. Various aspects, torts, various topics stand alone. Defamation is a whole area. And of late, defamation has also been quite busy as far as the litigation front is concerned. Almost every now and again, you see someone bringing the a defamation suit against another, especially those within the political circles, as it were. So defamation, you have to know what it is, know the various types, the libel and the slander. You have to know the various defenses which are available as far as the defamation is concerned. And of course, if you are including tort as part of the areas that you have selected, you cannot neglect the tort of negligence, because tort of negligence is very important aspect of the whole of tort. And negligence, you have to understand the duty of care. How is a duty of care established? You have to know the original position before Donegal and Stevenson, and then how Donegal and Stevenson came to create a general position, and how Donegal and Stevenson had to be refined and contained in terms of what you saw under the Caparo against the Dickman jurisprudence. And having established the duty of care, you must also go through breach of duty of care. A lot of things are over there, the standard of care to be used and so on. And again, where you may not want to have to even go through the full requirements of proving negligence, you place certain evidential maxim like res ipsa locuto or things like that. You have to know like the requirements, as it were. And you must always know the third requirement of negligence, the resultant injury or the consequent damage. And that will have to also involve causation, whether the injury or the damage being complained about, whether it was caused by the defendant's breach of duty of care, as it were. So if you know this, then you are doing well as far as the tort is concerned. And then, of course, when it comes to the trespass to persons, it's been examined over and over again, and it's not an area that, battery, assault, false imprisonment, malicious, what do you call the prosecution, and so on. Malicious prosecution, for example, last year, it became like the interesting. And then if you take the case involving Asamoah, maybe some, it's like a whole notes provided on that particular tort, as it were. Just as if we take like the case involving Kennedy Agyapong and the other gentleman, the whole notes involving like defamation, for example, was presented by the court in those cases, as it were. And of course, we have like a nuisance, occupiers liability. So if it is what that you're interested in, you have to make sure that all these topics are being covered. And then you come to the sixth one, land law. Land law is also quite vast. So if you are land law, there are some key things you have to know. Of course, you have to know your customer land law, particularly now the interests which may be held in land. Now, if you look at the New Land Act, it's like the customary land law and the common law has been merged more or less in terms of the range of interests which may be held in land in Ghana and all that. So you have to know each of those types of interests, their incidence, that is the bundle rights and responsibilities associated with them. And of course, you must also be interested in how those interests can be acquired or how they can be transferred validly in law as it were. And then you must also know your leases. You know, a lease is a major interest at common law, and it is a matter of interest for so many other common law interests which may be held in the land. So you have to know your lease. What is a lease? You have to know the requirements for creation of a lease. You have to know some of the covenants, right? Some of the covenants and stipulations and terms associated with the lease. And all these are in the Act 1036, the Land Act 2020. And you must also know how leases may be terminated or may come to an end. But mind you, a lease is a contract, it's contractual arrangement in relation to an interest in land. And again, you should also know perfection of title. How do you perfect your interests which you have in land? So I'm talking about registration. So you must know the two regimes: registration of title and then registration of instruments affecting interest in land. So you have to know these two very well. An elaborate procedure have been provided under the Act 1036, as it were. And again, you should be interested in the fraud, right? Especially when it comes like the defenses to maybe an action relating to land. Fraud, especially, very important, especially as relates to registration. So you have to know how the courts have dealt with that. And again, compulsory acquisition. Compulsory acquisition is also a very important area in land law. The exercise of eminent domain, which you have to take serious. Now, for mortgage, right? Mortgage and pledge, sometimes it's included in the land law syllabus. Other times, it is included in equity and succession. So if you are targeting land law as one of your 4 main subjects you are going to the exam with, then it will not be bad to also look at the maybe mortgage and customary pledge or pledge as it were, just in case there is something around that area. So if you are going on this path, as I have endeavored to explain to you, you have nothing to fear. Then the next thing will come to how you answer questions. Some of you have approached me, and I'll tell you that I tell them that it's not the case that you are not learning. You are learning, but if you do all the learning and you don't try your hands on questions, you haven't achieved anything. Do all the learning and you don't try your hands on questions, you haven't achieved anything. So I will suggest to you that the subject areas that you are revising and the topics that you're reading, as you read each topic, try and get at least 1 or 2 questions for that topic. 1 essay, 1 problem, and quickly sit down and try and sketch, write your answer and see how in your mind's frame the answer will be. And that is important because, mind you, you are learning towards examination. So the knowledge in terms of what you're supposed to know in the subject area is important, but how to use that to answer question is equally important. Some of you have written the exams more than once, right? You are not passing. It's not because you are daft or because you are not learning, no. but you are doing the wrong thing. The wrong thing in the sense that you learn, generally, you just keep reading. You don't make effort to question yourself whether you have assimilated enough and you'll be able to harness what you have read, what you have internalized to answer question. That can only be done where you actually close your books, get a question, try your hands on it. And then when you are done, you yourself look at what you did and then ask yourself, if this were to be like the question which I'm going to be giving the exams and I wrote this, will I be happy with it? Or you need to sit up. The more you do that often, it will challenge you to know where you fall short and then where you really need to put more effort. But if you just keep learning, oh, you are learning, okay. You hear that some people are doing some classes somewhere, it's very good though, okay. You go and join them. You hear that some people are doing some discussion somewhere, it's good, you go and join them. You can be doing all those things, keeping yourself very busy, but it's busy for nothing. Busy for nothing in the sense that you are not actually doing things which enable you to measure whether you are making progress with what you are learning or not. So these are the basic things I want to share with you tonight before I'll take a substantive subject tomorrow and then deal with you. But I will open the floor now. If you have some specific comments or contributions or questions, one person at a time. You put up your hand and then I mention your name so that we release your mic. And as I'm doing that, if there are maybe something that you'll be learning and you like me to do a full discussion on, you let me know. Maybe you are learning something and you think that we need a bit more instructions on it. Yes, if anything, just make sure that only one person is talking at a time. You can just release your mic. Maybe while waiting, other things I have to tell you. Okay. So they say that the network keep going. Is it the case that you're not hearing me?
We can hear you, sir.
Oh, right. Okay. All right. So the other thing I think I should share with you is this, and please pay attention to this. I'm telling you, when you talk to examiners who have been associated with this exercise for a long time, what they tell some of us is that one, some students don't write well. So you can't read what they have put down. Please, we are not saying that you should be artists, right? But make sure that when you read, it is readable. If you read and it's not readable, it cannot be read for the necessary marks to be given to you. And that would be very sad. So you keep writing the exams and you keep failing, you don't understand. It may well be that you wrote very good answer, but if it cannot be read, it cannot be read. And the person who is marking the script is probably marking about 500 scripts or 600 scripts. If he or she looks at it, he gives his or her best effort to be able to see what you've written, and he's not seeing it. He will just give you any discretionary marks and go. And probably write a comment that it cannot be read well. The chief examiner or whoever is moderating it will probably agree. You are failing the paper. You don't want to fail the paper. So please make effort to get what you are writing to be legible or readable. And two, avoid elementary mistakes. If I say elementary mistake, for example, you have finished 3 years or 4 years of LLB, okay? So if you are writing something like Land Act, we know the proper title for Land Act 2020 into bracket Act 1036, bracket closes. But you see a student writing Land Act 1036, then comma 2020. If you do that, yes, the question is looking for you to write a Land Act. You've given a sign that, yes, we know the Land Act, but the examiner will be angry and say that this is not a serious candidate. So you don't know how to write even a legislation at this stage. And the person will mark you down. So please, don't ignore those things. And again, when you write, it will also be good if you let the authorities stand out. If you can underline them, if there is time, that is fine. Or if you can write them neatly and all that. Okay. Yeah, is anybody saying anything? Otherwise, I presume that there's nothing to be discussed from your end. And tomorrow I just come and just talk to you on the subject. Okay, so somebody is asking.
Hello, sir.
Can you just write, just a second, somebody has typed a question in the chat. So maybe let me answer that and then I'll come to you. Can you just write Act 29, for instance, instead of the full name of the act? Good. Now, the person who wrote the question, how you have written the act, the second part, please don't do it like that. When you are writing an act of parliament, the first A should always be capital. Whether it's in the middle of a sentence or at the beginning of a sentence, it's always capital A and then the small letter CT. So please, let's keep that in mind. It's very important. And again, coming back to the question itself as to whether you can write just the, what we call like the act number. Yes, you can, but the good practice, okay, the good practice requires that. I can't see the question, is it gone? Okay. Oh, yeah, okay. So the person said, can you just write Act 29 instead of, let's say, writing the whole of the criminal, I think criminal and other offenses act. I think that's the full title, isn't it? 1960 Act 29. Well, the best practice is that when you are writing an answer for the first time, if you can and you must, write the proper title of the legislation. Then subsequently, that is after the first time, anytime you need to write, you can just write maybe the act number, Act 29, Act 30, Act 1036, Act 25, or whatever, okay? But if you have only forgotten the full title and then you remember just at 29, then not writing it is better than writing the act number. Yeah, so then you write that. Yes, somebody wanted to speak.
Yes, sir.
Yes, go ahead.
Please, sir, I want to find out if the discussion going forward would be subject to your availability, or we would have time frame within which to expect that the discussion will start in the days that we'll be having the discussion.
Yeah, unfortunately, as I speak to you now, I'm not in Ghana. So as and when I come online, I just put I'll prefer is 5 p.m. Ghana, then 5 p.m. 5:30 p.m. Ghana time. If my schedule at where I am permits, I'll do it that time. But if it doesn't permit, anytime I'm able to come online, I will do it. That is why I have about 15 or 16 platforms. So when I put the link there, if it's convenient for you to join, then you join. If it's not convenient for you to join, we try to upload the recording on the Ghana Law TV channel. You can go back and then play it at your convenient time.
All right, sir, and thank you for your time too, and the fact that you do this for us almost every year. We really appreciate it.
Any other comment, question, contribution? And when you are quiet like this, it gives me confidence that all of you are passing because you are ready to answer every question, and that is good. That is very good sign. But if something is worrying you, don't be shy or afraid of anybody. That is why I am here. And all of us are learning. So the fact that we are here means that we don't know. We are learning. So just feel free and then ask the questions or make contribution. And the more you are interactive, the more I enjoy meeting you. But if it is just monotonous, I find it boring. Is there anything in the chat? No. Okay, then in absence of further comments, we've ended our introductory session. So tomorrow we have more sessions. There are times that I may do 2 or 3 sessions in a day, depending upon my availability. But as I said, when it's being done, I just put the alert on your platform. And then you can join if it's convenient for you, or you can later on go to the Ghana Law TV and play it back. Have a good night.